or a social event is having investigative or prosecuting functions and the laws of any territory in relation to criminal offenses involving prohibited weapons, firearms, or ammunition. And then section 6, the minister has to approve this to enter into a memorandum of understanding or other agreement or arrangement regarding the exchange of information. There are two things I really asked that this language seems to satisfy should satisfy what the SG is asking for, SG are on, and it's also satisfied my requirement because the agency is still broadly defined, but there's a gateway. The minister must approve, so we're not going to approve an arrangement with some agency that's a fly-by-night agency. SG, you have any comments on this before we move on? The new structure.
Pardon me, sir. I'm only seeing Shelley and Thompson from the AG's office. I'm not sure if she has the information you're requesting.
Well, just comment on it because they had raised the issue that they.
Hi, good morning,
Morning.
Minister and members of the committee and all other colleagues. I'm sorry, I'm not able to speak on that issue just now, but if you could allow me a moment and I will revert to the committee.
All right, please. Your SG had raised the issue that we had broadened it was too broad and may in breach of the Data Protection Act or some in the whole question. But first, it was not personal data we're dealing with, it's firearm data. So I think you should bear that in mind that the exchange of information does not deal with individual identity and personal confidential data. It's the firearms, data on firearms, prohibited weapon, firearm, or ammunition that is being interchanged between agencies involved in investigating and prosecuting illegal weapons trading, essentially. The CPC has reorganized the language and also strengthened the question of the ministers, the memorandum of understanding or the agreement with the agency have to be approved, those contracts and memorandums. And the registrar of course was satisfied that the agency is subject to adequate legal restriction in their own jurisdiction. That should satisfy your asking for, but we have to keep it broad, given the areas where we're looking at. But you could inform yourself, Shelley-Ann, Ms. Shelley-Ann, didn't get the last name?
Thompson, Minister.
Thompson?
Yes.
Let us know. But I think the amendment satisfy me, and I think it should satisfy USG because I said it clearly defines the required gateways to the exchange of information. And second, I said it does not involve personal data, it involves the data on firearms.
All right, noted, Minister. I'll liaise with the SG and then revert.
All right. Any of the next section? Okay. 101, that's page. Right. Mr. Richards, you're on. We have an amendment to 101 in the proceeding against the first found offense against this act. This was
That is correct, Minister.
Hello?
Yes, Minister, that is correct.
That's correct. That's 1017.
Right. As well as the 98 where you will go back there.
102. Added. No further comments. My colleagues there now. Senator Golding.
Morning, Claire. How are you?
Morning. I was trying to catch your attention there. I apologize. I had a last minute call with
I'm so sorry. I had stepped away when I was waiting.
Yeah, and my apologies. I said I had to have a discussion with the chairman of the Integrity Commission, another matter, and it delayed me a few minutes. All right.
Okay.
I think
Chair, just to indicate, Senator Sinclair has indicated he's having some internet issues, so I think he's still trying to get on.
All right. Thank you. He's usually my faithful supporter. My senators.
Yes.
So both have what are the other sections of correction, Mr. Richards? I've identified the two, Senator Gold. You might have had the one in 89 has been clarified in a sense, been just made clearer, while it kept being broad enough, but with the required hurdles to ensure that we don't end up exchanging information with some inappropriate agency, and to remind that it was largely firearm data we're dealing with, not with personal data. And section 101, have a section 7 added, and 102 added, and 102 now become 103. The 102 deal with the obstructing or resisting by threatening language, etc., an officer in pursuit of their duty. It's something that, in fact, is coming together. I think there are other legislation with it involved, obstructing a policeman in executing his job, which is becoming a challenge. In fact, I think on another forum, we are asking the police to publicize this as an illegal act and that it has consequences, because we have been having a number of incidents along those lines. Sir Richards, any more?
Yes, Minister. Just to clarify, the amendment, the additional amendment that was made to 101 was really just to expand the reverse burden, or to amend how the reverse burden clause was originally drafted. And there was also an amendment to clause 98 in respect of control delivery to also expand that provision.
We have had some, again, the control delivery, I think it's more, again, a clarification, because it is part of the, what section are we at? Control delivery. Yeah.
Right, it's just to expand it a little bit, Minister, to also include the allowance for exchange with dummy items.
Yes.
Right, and this was discussed at the last couple of meetings.
Yeah, that's okay. I think that covers the primary change we made in the last meeting. You recall anything else, Anila, Mr. Richards, Samantha? Mr. Media with us. You don't want to make my short notes, Mary, the last year was a bit impaired. I didn't make a rough note.
Pardon me, Chair. You're still a little bit low.
Yeah, go ahead.
No, I was just telling you that you're still a little bit low in your volume.
So I think those identify the major concerns we had the last meeting. I don't have my crude one that I wrote up on my little sidebar with pencil. But I think we covered all of those, the principal ones. Mr. Richard, do you have any other notes of any matter?
No, but just to point out as well, you're correct, Minister. Those are things. Right. Those would have covered substantially what the committee would have discussed. There was one particular amendment which we had asked the CPC to make, and she's including that in the draft, which I just sent to Ms. McCarthy, was for there to be included a provision for the Institute to be able to modify ballistic signatures. And that rationale was appropriately provided. And that is now included at clause, sorry, as I try to maneuver my way through the new bill. Is it?
Fine.
31? Let me try and find it, Minister.
So we're near the ending, like we can take this in Senator Golding. We may have some debate, but I think we're well prepared for it. And I know you'll cover me in the upper house. I think that I'll mention two things. One, I think Senator Scott Motley is on. May I welcome her?
Thank you, Minister. I'm in a very strange sort of environment where it's better for me to listen than to speak. I'm in a lounge of a hotel getting ready to travel shortly.
Oh boy, all right. Understood. Thanks for coming in anyway. You know, even when we disagree, I appreciate your presence, really, and your contribution.
Thank you, Minister.
If we disagree in principle, not in a contentious manner. No, you have really helped us in getting this thing through. All right. So if we have gone through that, there are two things I wish to mention, because I think the other thing we have to do for today is look at the minutes. Am I right, Anita? Have you circulated the?
No, not the minutes, sir, the report. In the draft form, because I'm still working on it as we go along.
Right. Okay. So you have that circulated, or does the draft bill? The report?
No, sir, it's just the draft bill that which I just got from Mr. Richards that I circulated to members just now.
The report that to be taken. Can we get a draft up today, or we have to do it tomorrow?
I would prefer for it to be done tomorrow, sir.
Colleagues, we'll be on Zoom still, so hopefully we can get it done, because I'm trying to get the steps done. If we do that, we'll be able to go to the house on Tuesday. Guide me, Mr. Richards.
I think so, Minister. But just remind you that some of the minutes you have not yet confirmed from the discussions.
So I would bring those tomorrow. I would send those out today for tomorrow's
meeting.
We're approving
this. Now, for the members who are on, we got a very late submission, and I'd asked Richard to go through it. I find that a little bit, I don't like to, I'm not a contentious person, Senator, but the correspondence was a little bit off, if I might put it mildly, because the person was saying they were not aware there was an opportunity for public submission.
Chair, if I might just indicate, I just returned from traveling last night, and I did note the email sending out the late submission. I have not had a chance to peruse it. That comment alone is a little odd to me, because this work of this committee has been so publicized that I can't imagine anybody not being aware that public submissions were asked for.
And I think she did something a little bit unseemly. The person who did it, I don't know who did it, two things a bit unseemly. Besides, I said, but I went through it, and there was nothing fundamental brought up that is new that would force us to go later. But there's something with, and I'm glad Senator Scott is still listening. You see, I think this committee has made a good model of good parliamentary work. And I said it as, in terms of our committee, that we work together, we discuss differences, even where sometimes opposition agreed with government members agreed with the opposition despite of discussion from the chair and so forth. It was good dialogue, constructive and so forth. And the individual sent it to some of the opposition members, not all, some, nobody from the other side. And if we're trying to introduce some dissonance in the team, that's all the lips, whoever knows them well could speak to them, because that's not very nice. So I'm not going to take it. I said there's no good reason to take it. It is late, and there's nothing new or overarching in there. And it was
Chair, Could I
Go ahead.
ask you just to give me a chance to look at it as well, please? And
Sure.
if I
I
have
think-
any additional comments to make in relation to it, like if I could be permitted
No,
to do that
I
tomorrow?
think Anila circulated among all members later. She did send it to the email.
No, she sent it here. I was just indicating that because I traveled and got in very late
Yeah,
last
no,
night.
I
haven't
appreciate
had a
that.
chance to review.
So
Yeah,
I say take a look at it, and if you have any further comment on it tomorrow, we could.
I'd be grateful for that opportunity, Chair. Thank you.
No restriction on my members looking at any submission, but I thought the submission a little bit.
That wouldn't be in your character, Chair. That's not what I'm used to.
You know, unfortunate. All right. Is there anything else? And the meeting is going to be short today. We have approved the amendments, Minister. Your legal presence, Mr. Richards. So in fact, we have accepted the amendments by the CPC, and I want to thank her in particular. I'll do it more appropriate as we go through. And tomorrow we can just approve the ministry haven't done yet and accept the report with a view of getting this to the House on Tuesday. And we know in the House we can still have some discussion. I don't think the members will have a chance to go to the entire bill. It has been an instructive experience for me, not being a lawyer. And the legal team, it's 149 pages. Mr. Richards, please, leaning on you now. Samantha, anything else to examine? Comment. If not.
Not from our side again, Minister. There were two clarifications that the CPC requested. So I'm instructing her momentarily. So I think a revised set of revised amendments will be sent out, I'm assuming.
Which of the section you want to revise?
It's just a clarification in respect of the definition for 3D printed firearm, as well as there were some square brackets in one of the clauses that we didn't instruct. So I will just send those clarifications.
Amend this section on training of juniors. Said we could accommodate some. It is the challenge radio that they're on the 3 approved trainers, and with the FLA would now allow licensed firearm holders who do sports shooting to allow to instruct. I think it was to guide them as they proceed into getting their permits, etc. That was the discussion really, and how you put that in language. So it was not a matter of changing the entire structure, but it's to ensure that the experienced sports shooters, as in using air rifles and shotguns, could legally, they do it now, but to ensure that we have a new act, that they do it within a legal framework to instruct or guide, you may want to use that term, individuals who are going to arrange to get familiar with the firearm. To do so, not all the range instructors are approved trainers. I think that is where we had a difference, Mr. Richard, when I look back at it. There are specific trainers approved, but almost every range, not all range operators are actually approved trainers. You have to go to a particular course and definition to get them as trainers. And they're still approved to provide services at ranges. And in the case of the sports shooting, it's not just a wild shooting, it's all people who are licensed and involved in sports shooting who are introducing those who have, the younger ones to the sports shooting activity. They are on the 3 kind of, you might say, approved trainers, which makes narrow the basis. But there are several people who are involved in training and has done so quite successfully over the years. And we had have to broaden the term approved trainers. And the affiliate does that quickly, or we have to give some framework to allow the seasoned sports shooter to introduce others to the sport. You don't need a major in it. It's just a matter of how you define trainers in a different way to accommodate those seasoned, established licensed sports shooters. Senator, I think you're aware of the concern there, and you're familiar with the sport as well. more than that.
Yes, Chair. I am aware of the concern. Unfortunately, at the last meeting when you had the discussion, I think that was the day I was traveling out and I had to come out of the meeting at the time. But just for clarification, the committee had agreed to try to find a way to incorporate it in the new. Okay.
Opening up with total is to ensure that we can allow for the introduction.
Yes.
But right now, you are being introduced to a firearm by a licensed firearm holder, can be held for use of illegal firearm.
Yes.
There has to be some legal framework since you're putting a new law in place.
Agreed, Chair.
Right. The trainers are defined and they become people who have to, it literally become, once you go to a trainer, it's a transactional matter. It's his profession. As opposed to a seasoned sports shooter will say, look, you have gotten your permit and I will, you're going for your permit, you're now 12, I'm going to introduce the sport, and there's a process over time, a couple of months that they will be allowed to use and get exposed. So look at that, Mr. Richards, we're meeting tomorrow on it. Tomorrow is 2:00, I'll be on time, and I'm sure we should have a long meeting either tomorrow. See if we can really accept the report. Anila, I take you have been very supportive. I know you're under pressure in Parliament, and therefore we'll, reserve both days so we could do this and get it to the bill to the House on Tuesday, so that all our members and the members of Parliament and interested parties can have a kind of final look over the break. So we will not debate the bill until September, senators, which is a good time for us to review again and still have a final look at what's a very critical and sensitive bill. We know we
Chair Sullivan has her hand raised.
Huh? Yeah. SG.
Solicitor General has her hand raised, Chair.
Yes. SG.
Thank you. Yes,
Can
morning. Thank you. I'm sorry that I was late for the meeting, so I apologize,
Oh,
Chair.
I was a bit there. I have to apologize. I was caught with another member of another independent commissioner. Go ahead.
Right. So I just wanted to find out, because it doesn't seem as if any change was made to the burden of proof provision, and we never got a response.
101?
I think it's one, right. I'm trying to find it quickly.
There was some changes made.
Yes, 101, 1017.
1017 is new.
So it reverses the burden of proof, but we didn't get a response to our letter, and we had requested additional instructions.
It reads now, Mr. Richard, any proceeding against any person for an offense against this act, it shall be necessary to negative by evidence the existence of any firearm authorization or any other matter of exception of our defense, and the burden of proving anything referred to in the paragraph A or B shall lie on the person seeking to avail himself thereof. That's what your concern, SG?
Right. So we had been asked to provide advice on the shifting of the burden of proof. We provided advice, but we were unable to come to a definitive position because we needed additional instructions, and the instructions were not clear. As in, we weren't sure how it was supposed to have been achieved fully in the bill. I'm seeing this provision now, so I'm just trying to understand what has unfolded since we gave our advice.
So we are, if I may, Soljan, we are working on the response to the chambers. We have issued instruction to CPC. So the chamber should get back the response sometime during the course of today.
So if I get you right, you sent instruction to CPC, but you didn't respond to the SG. That's not the proper routing. I have to ask the SG to forgive you in that one, but normally goes to both simultaneously in the face of the challenge we face with this bill. Am I right, SG?
So to be honest, Chair and members, this is not a very easy issue. So my colleague, Ms. Thompson from these chambers, and I worked on that opinion. It's not easy issues, and it's not something we can rush through. I'm just saying that. So I don't know. So I don't know what the response will be, but we had a number of things that we would then have to reconsider depending on the responses, and it wasn't just one issue. I don't know that that's something we can undertake and complete overnight.
SG, can you give me a bit, outline to me what your concerns a little bit more, not in terms of, you know, just from my own knowledge of exactly what you're dealing with here.
I wonder if Ms. Thompson, because to be honest, I'm not even, Shellyan, are you able to go through? It's very nuanced though, Chair.
You have been teaching me law otherwise. I'm not going to hold it. I just want to get a bit of understanding of.
Sorry, can you just give me a minute to confer, please?
Yeah, please.
Oh, okay.
In the Pardon me, sir.
Yeah, I'm going to.
Ms. Cunningham from the Parliament has her hand raised.
Okay, Ms. Cunningham.
Hey, good morning. I was just pointing out, just for tomorrow's meeting, or perhaps it can be handled today, that in the new document that Ms. McCarthy shared, there were some square brackets in the document. So I don't know if it is that the committee needs to decide on those square brackets. There was a new square bracket in clause 98.2, and then there was a square bracket in the third schedule at clause 13, a new subsection 8. That one is, the square brackets are empty. And then there's a new square bracket in 98.2 that the committee would need to address. Thank you.
98.2.
Chair, Ms. Shellyan Thompson, who is Crown Counsel in these chambers, is prepared to highlight some aspects of the opinion. So some of the concerns that we had.
Thompson. Okay.
And maybe not even concerns, we just wanted to highlight that there are different elements to a test.
Concerns are highlighted though. I need your
Sorry?
I need your input, whatever way you place it.
So I wasn't hearing you, Chair.
I'm saying no, you don't have to, but there's concerns or questions answered, I need them.
Right, no, I just wanted to clarify. It's not so much concerns, it's just that what we have to do is tell you what the test is, what the court says the test is, and then the different elements of it and what we would need to demonstrate. And there were certain things that we did not have instructions on. So I'll turn over to Shellyan.
Hi again, Chair, members of the committee, and let me apologize. I do understand that for the purposes of PBCJ, it is required or preferred that the cameras be on, but unfortunately I'm having some technical difficulties, particularly with my broadband, so I'm unable to. Just in summary, really quickly, we had received a draft opinion from the Minister of National Security and we did peruse it. However, we wanted the committee to be reminded that the test of constitutionality, and that was the issue that was raised, whether the reverse burden would have, as proposed, to be inserted into the draft bill, whether it would have met the test of constitutionality. That test was laid out in the decision of Julian Robinson versus the Attorney General of Jamaica. And they laid out four components that would need to be considered and needed to be met in order for a proposed law or a law which is enforced to pass the test of constitutionality. And it needed to have, basically, it needed to be proved that it was for a proper purpose, firstly, that there was a careful design, that there was minimum impairment, and that the effect was proportionate. Some of the challenges that we had, we were not entirely certain. We needed clearer instructions. It seemed to us that the purpose, certainly we were able to glean an understanding of the ministry's purpose for introducing the reverse burden in respect of the prosecution of offences under the act where a license was involved. However, in order to be able to speak to whether the proposal met the careful design and certainly the minimum impairment components, we had a challenge. We needed instructions on whether other options had been explored by the ministry, whether it was determined that there was no other means by which the information could be obtained in terms of the whether the person was authorized in respect of the offense that they were said to have committed. So those were some of the challenges, because a court considering the matter, it may very well be that if there is another option available, it would not meet the requirements of a careful design, and it may very well not meet the requirements of minimum impairment. So we needed to hear back from the ministry on that issue to be able to come to a definitive position as to whether or not the reverse burden as proposed now would meet the test of constitutionality. That is just a summary of the opinion that we sent back to the ministry.
No, that was quite clear. I know in public space, I was careful the comments I make, but the case referred to may need to go further in terms of, I know there was this concern that some of those opinions were not challenged at another level. And one we might have to find a law to do that. When opinions are questioned, and you appeal it to the highest appeal court. And if you don't proceed on another occasion, as has happened in other jurisdictions, another case is brought on another issue. But that's another matter, SG. But you're quite clear, Ms. Thompson, and I have a better understanding. And Dr. Richards, though, this reverse burden of proof where the licensed firearm is the controller. But I do in the back of my mind as well, because I think there could be the issues raised by Ms. Thompson, all 4 questions raised. I can't repeat all of that. The purpose and etc. could be is easily justified where a illegal firearm is concerned, but there may be some challenges with a personal authorization. Ms. Thompson, would I be correct in saying it that way, that layman's term? Ms. Thompson?
Well, sorry, Minister.
I'm saying there's some, because we're dealing with 2 issues here. I'm saying if the question you raised 4 concerns based on the court ruling. I'm saying listening to them, I think they could be easily answered where a prohibited firearm is concerned. But in the case of a legitimate firearm, whose authorization is properly registered, we have to find the appropriate justification.
The challenge. Go ahead, SG.
Yes. Yes, I understand. But you see, Shellyan also did a summary based on the strict test. And by the way, the test, although coming and emanating from the Julian Robinson case, has now been affirmed in subsequent cases. So it's not just the one case. There are other elements, but on top of that, there are other elements that we did not get instructions on to be able to advise. So for instance, is the measure supposed to be of general application or only applicable to 1 or 2 offenses? We weren't sure about that. And that is important, especially when you're going to look at the sentence that is likely to be imposed if a person is convicted when they are not able to discharge the burden that has now been placed on them. So there's case law to indicate, for instance, that there's no major legal difficulty when the reverse burden is more of a regulatory nature, but it depends on the kind of sentence that's going to be imposed. So in a lot of jurisdictions, it's not usually imposed on offenses where the person will have a custodial element or a very serious custodial element that we had no instructions on. That is something that the courts look at when they look at a reverse burden. just to see the kind of sentence that is likely to be imposed. If they think it's very harsh, that may work against the intent of the state to have that reverse burden. So I'm just highlighting that although Shellen gave a summary in terms of the elements of the test, there are other aspects that we requested instructions on, which could likely indicate whether or not you should go in a certain direction.
Yeah, and no SCM, I'm seeing this reverse burden proof stuff. I know we took, I think, what is it? We wrote out of the Constitution, which was in the new charter. And
right, and so what the advisory committee that advised the Joint Select Committee on the Charter of Rights to remove the provision, their concept and their thinking was that the common law should prevail. You should use the common law. Whatever the case law is telling you, that is what you must apply. And at the time, the case law was evolving. And so they thought this was the way to go. And that was part of the thinking with the removal. So the point, though, is we now are governed and guided by that. So on top of the strict constitutional test, we also have to look at the case law surrounding the reverse burden of proof. And I'm saying that generally it's applied for regulatory offenses. These aren't really regulatory offenses.
Oh, no.
And what we needed to know is which offenses would this apply to? What could be the likely sentence? Because these are things that the courts look at.
No, we're looking at even life sentence in some of these.
And so, and so a part of the whole constitutional test of careful design could perhaps lead you to say, well, we will not do this in a general manner, but we will restrict it to very specific offenses. But those are some of the instructions we requested.
Mr. Richards, what's your comment here? Because there is a layman understand that makes, to me, the comments are fair and reasonable in the face of what we have. Mr. Minister, you have the comments there. Mr. Richards, the comment.
Minister, as I noted earlier, we were actually working on the response to the chambers. The intention was really to get it across to the chambers today. Unfortunately, I haven't been able to.
We don't have too many to and fro, you know.
Right. So
I don't want it to be up to whether this the clause as spread stands look very general and open. And in this case, I have to agree with the SG without any hesitation and a policy point of view. I don't want to have I cannot write a broad clause that actually does not recognize the current, rulings of our High Court, because the reverse burden proof, as I said, was written out. I think that's the term used legally. I've learned a few expressions, SG, from you, in that it was taken out and literally the Constitution is silent on the matter from a layman's point of view. And what we have to go by is the rulings of the court, which have been laid out quite clearly in the cases outlined by SG. So I would want to have a major defect of this sort in the bill. If it's not there, does it do any harm to the bill at all? And you revert to common law? I would ask.
The issue, if I may, Minister, is that with the definition of prohibited firearms, where we have now said if the firearm has not been registered in another jurisdiction, there is no way, for example, for us to know that that has not been registered in another jurisdiction unless the individual were to provide such an authorization for the prosecution. So this is where we actually want the reverse burden to apply. It wouldn't necessarily apply to the entire, to the regulated sector.
The person have to show that it's not registered, that it was registered, but if you don't have the registration, it is a prohibited firearm.
If you're not able to demonstrate that you have a registration for it, yes, it will be prohibited firearm.
Yeah, but But how does the reverse burden proof come in there? Because clearly,
Because then you'll have to show, because what we're saying is that you'd have to show that you actually have a registration for the firearm.
I'm understanding what I'm saying. If you're in Jamaica and you have an unregistered firearm and you're not authorized to carry it because you do have some that slip through the system, then you have a prohibited weapon. If you say it's registered in another jurisdiction, there's no need to codify his response here. He has to bring the proof. Until he brings the proof, then it's what we have.
So that's the reverse burden.
No, that's not a reverse burden. If he says to you by word of mouth, that's not a valid. How do I codify that?
Yes, but you're not putting the burden on the individual to say that I actually have a registration.
Yeah, no, what I'm saying, if someone just walks up with a legal gun, import from Colombia by a fishing boat, and so well, it was registered in Colombia. That's not. Well, I don't know. Laws advise me. How does that evidence, how his comment affects my evidence? If he allows SG.
So, Chair, that is part of the issue. So again, the courts will look at how easy it is for either party to be able to produce the information or the evidence. So generally, it would have been on the prosecution if bringing the charge to say you actually have an unregistered weapon and it's not registered anywhere. The issue then is whether or not the prosecution here would be able to liaise with other jurisdictions and get that information.
Yeah,
so the issue is if it's impossible and we didn't get those instructions, if it's impossible, then that is a big argument to make when you're saying that you have to have a reverse burden. If there is some comparable ease on either side to be able to obtain and produce the evidence, then that weighs against the reverse burden. So again, these are some of the things we ask.
I'm with SG. This is what I'm not cross-examining, but clearly. So the guy goes to Colombia, hundreds, and bringing some illegal firearms. He comes to court. I don't have a exchange of information.
Sorry, but before he comes to court because there is a charge.
Right, that he has an illegal firearm.
Right, but before he's actually charged, so before he comes to court, there should be a file. So the issue is it that the prosecution cannot get the information from Colombia? And this is why we're saying it is for the man to come and say, I have this, and produce his license. And then on the flip side, what I was talking about, the likely sentence that can be imposed, what the courts also look at is what happens in the event the guy really does have the license in Colombia, but because of all sorts of challenges, he's unable to produce it. And then he could now be sentenced to life imprisonment because we have said he must prove that he had this license, and it was very difficult for him to prove it because maybe the license was somewhere in some apartment in Colombia, he couldn't get it, and the authority there didn't want to correspond with him, or something along those lines. So you have case law explaining those kind of principles. So this is why we needed to get the information so we could also try to assist the ministry in coming to a determination on the matter. Because these are things we don't know.
No, I appreciate that, and I'm giving you a little bit more problem. I'm saying, so I'm dealing with illegal firearm dealer in Jamaica, right? A Jamaican who is resident in Jamaica, he goes in a boat to Honduras or Colombia, picks up illegal guns, 3-4 of them, bring them here to Jamaica for sale. They may still have the marking, they may not have the markings. So when I apprehend him in my territorial waters he's driving to St. Elizabeth, loads them on a pickup, and I apprehend the pickup with him in there. He has firearms he clearly brought in by a fishing boat. We have that evidence, which is not a normal trading activity, an illegal boat as well, because it's a cigarette boat which only does illegal trading. Catch him with the firearms, they are clearly not registered in Jamaica. He has no authorization for them. So that to me is he has a prohibited weapon. They are saying he can go to court and say I registered for them in Honduras, and I must go and get the information from Honduras.
No,
I
so
can't.
no, but stop right there, Chair. So that's the whole
Yeah, that's
point.
why I'm
No, so what is he being charged with?
It'll be
Because
charged with legal.
that's why we're asking, you know, what do
Okay.
you want the reverse burden to apply to? What is he
Right.
being charged with? Because if he's being charged with not having a weapon registered in Jamaica, why would you need to reverse that burden?
That's why I'm
Because
trying
you
to get
should
to
be
know.
able to
Do I need
prove.
this? Do I need this? You see,
I
I'm
don't know. I can't answer because we
no,
don't have those
no, I know you can't answer,
instructions.
but I'm trying to get to my
Right.
own mind to satisfy myself that do I need this clause in it at all? Because if I
And you
find him,
may, the thing is you may, but I don't know. And that's why we're trying to figure out which offenses would it apply to. So if it's a offense about not being registered, the weapon not being registered in Jamaica, then you shouldn't have the reverse burden of proof. I think it would relate to if you're now needing to prove that it was not registered elsewhere.
yeah,
I think
that's what I'm
that's
saying.
where it
But
comes
what
in. We still
you're
weren't,
saying to me,
and remember the clause that is there now is a very general application, which is a problem.
I'm with you on this one completely, you know, you see that it is too broad because
Oh, I apologize if I seem like I'm arguing with. Sorry, about that.
no, I'm with you.
This is how we do things, and people don't know details.
No, SG, because I will have to argue it when it comes to Parliament, right? And so it comes here, and if it goes to court, I have you to defend me. But when it's in Parliament, I don't have to take what I acquire here. As he said, the goal is speaking. What you, as the SG and Senator Gold, because the lawyer teaches me here that I can speak to with some clarity. And in fairness, that's part of what I have to do as acquire as a legislator. Though, and before Senator Golden come in, you see, I'm really questioning the need for the clause because where it becomes the case I've given, I think we would not need this clause in a man trafficking and having a number of firearms unregistered in Jamaica, all of that. I don't see how a lawyer could really spin that to, you know, take that question that far. Where it would come in is the
That's exactly where I wanted to support you on, Chair.
Right. So where it could become a challenge, and I want to comment in that argument of the SG is now the lawyer who comes in from Chicago or Montana, where he does require a license and then a permit to bring the firearm in. He may need a carrier's permit if they have to conceal, because they say they have to carry it concealed. Now, New York say you don't have to conceal it. So we have different jurisdiction. But let's say it's from a jurisdiction where all they need is a permit to carry a concealed firearm. But there's no problem in getting it. They're flying to Jamaica as a tourist, and he's going out, and the firearm is not registered in Jamaica. So technically, it's a prohibited weapon. And then it will be on them now to get the proof that they have the firearm legal in the United States. No, that's a case where we could end up with a bit of a problem. So I don't know if this can, and we treat those. The courts have been able to handle them because they go to court and it's demonstrated that, they basically had that firearm that inadvertently for whatever cause we have, and the court releases them. So do we really need this clause? That's what I'm asking Mr. Richards. Based on the arguments we forwarded, it would require a fair amount of a much expanded clause 7 to define, to isolate the cases you need to apply it to. I know that you can also include a trader who is a big trader. He dumps all the guns he have except one that he wants for himself now to take the other one or call him from Colombia or Honduras. And that's what we can maybe catch him on. You have been trying to catch him for a long time without any hard evidence. And you want him to prove that that firearm is registered in Colombia. And he will say to you, well, this one I keep is my personal firearm and I have it registered in Colombia, and you yourself go and get it. But I don't think there are so many cases. I don't know if it is, I don't think you'll have so many cases to justify putting the law through this rigor. Senator Golding, you're about to comment. So.
Yes, Chair. I share many of the meanderings that we're going through now. But I just wanted to say, when you look at the amendment as it is drafted, the reverse burden is in respect of the existence of any firearm authorization or, and this is a very, very broad and general part, any other matter of exception or defense. I cannot see the justification for Part B of the amendment being so broad. But certainly in relation to the scenario that you have suggested, there are a number, and SG had asked several times, what would that person be charged with? Because in relation to the registration of the weapon, of the existence of an authorization, even before the existence of an authorization, the question of how the weapon is reaching our shore would be, that authorization would be in relation to the Firearm Licensing Authority, not in relation to an authority outside of this jurisdiction. So that, in my view, would not justify reversing the burden on the person, because the prosecution should be very easily able to determine whether or not the question of importing the firearm or the weapon. Well, this is it. So if there is no permit import, no permit to bring it in, then that, in my view, would satisfy the prosecution having the burden to prove whether or not an authorization exists. When you're talking about registration in another jurisdiction, it would seem to me that's now going to the question of possessing the weapon, possessing the firearm. But there are a number of other breaches that would happen before that. So in terms of, is it narrow enough to justify the reverse burden? On the face of it, I don't think so, but I would also await that clarification of instructions that the SG is seeking, and that the team has indicated they're providing.
Minister, Minister.
Yeah, yes, Miss.
I'm not
Nadia.
I'm not really in a position to see if anybody has their hands up.
Yeah,
but I
Mr.
wanted
Williams
to-
has his hand up. MP Williams have the hand up. So if you want to speak, he'll allow you the lady to go first, and then I call it him. Ms.
Well,
Wilkins,
what-
No problem, Minister.
Thank you so much. The first question I wanted to ask was a practical one, which is how much time would it take between the ministry and the SG to work through all of these issues which have been raised? Because they seem like very significant issues. And I think I'm struck by the fact that the SG has raised the generality of that particular clause. My own concern is that there is no way that we should be crafting legislation which raises issues about its constitutionality. And so I certainly would want them to have the opportunity to find the best way to deal with it so that the objectives of the ministry can be met, but at the same time, the legislation can stand up to the scrutiny of the court. So I want to have an idea of, I know that you want to have it before Parliament on Tuesday, and that is why I'm asking, how long would it take to resolve these critical issues?
well, I appreciate that, Senator, you very pointed, but my question, my question, do we need this any at all? Because from what has been said by the SG and the way to define, though, it's the way to, the offenses are referring to. I don't know if we need, I said, this kind of clause. As I've said, the reverse burden proof is a significant issue on the Constitution. I don't want anything on the margins of the Constitution at all. I agree with you on that we don't want to push the boundary on that issue too far, even though we are going with some, pretty aggressive legislation here. But from what I've heard so far, I was just trying to find, to convince myself that not just from a point of view of the legal frame, do we need this clause in at all? Outside of the SG indicates regulation, yes. If a Jamaican turns up with a firearm, it's registered and everything, but he doesn't have his firearm license, then he's required to produce the license in 24 hours. It's up to him. That's kind of a mild one. Looking at it, we didn't find his registration because his name was had error on it or something of that sort. We have to give it time to find it, and it would justify in him being allowed to. It would be appropriate to lock him up for life. So we have to find a route for him to go find his license, sort out the details. But for the people we're looking at, the traffickers and the contraband traders in the legal farm, do I need this any at all? That is really where I'm, Senator. I'm not because of the time.
I guess Mr. Richards can really guide you on that now.
So I'm going to ask Mr. Williams to come in before we go further. MP Williams was trying to come in.
Thank you very much, Mr. Chair.
Mr. Williams, you put on a special camera this morning. My colleagues here looking for change.
Yeah, thank you very much, Mr. Chair.
Trying to impress my two senators because they're coming.
No, Minister. I'm never an impressionist. Yes, but I would just like to ask a question of Mr. Richards, because in addressing the question of the reverse burden and the legal requirements and the test for constitutionality that was so, ably outlined by is that Miss Grant?
SG, Miss Thompson.
Yes, the SG. No.
SG team.
Sorry, no, it was Miss Thompson.
Miss Thompson, yes. So ably outlined, and the test of constitutionality. Now, my question is this, Mr. Richards, because following upon what I heard you say, you seem to be confining the reverse burden to that HD principle. I just want to know if it is that you're abandoning, or if it is your view that you would abandon the kind of wide application, for instance, in the local context. And is it that you're just limiting this reverse burden? Is it your intention to amend and to limit the reverse burden to the HD context, the 3D printing circumstances, where you outline that it may be very difficult to, in the circumstances on a cross-border basis, for the Crown to easily establish registration? I just wanted to be clear on that, because my view is that in that limited context, the reverse burden could satisfy the test of constitutionality, because I think it would capture the careful design test. I think the minimum prejudice and the difficulty of the Crown here, albeit that we now have, I think there is a section in the legislation which allows us to cooperate with law enforcement agencies abroad to communicate and exchange information, which, based on the latest amendment, is not necessarily personal, but restricted to firearm. Well, that could be a spokes in Mr. Richards' wheel, if it is that the Crown here can easily ascertain that registration information in relation to 3D printing. So that's where my head is, and I would just want if Mr. Richards could say whether it is he's leaning towards a more narrow use of the reverse burden in that context.
Right. So remember, it was always intended to be that the reverse burden should have really been applied based on how the prohibited firearm is, based on how prohibited firearm is defined, which says that any firearm in respect of which no firearm authorization is granted under Part 5 or under the laws of another jurisdiction. It was always intended for us to apply it specifically to Part 2 of the legislation, not necessarily the regulated section, because we could always find information on registered firearm holders. The thing is, there's no established mechanism for the exchange of information or to easily get registration information from another jurisdiction. In a case where somebody might have been stopped, and the minister would have pointed to an example, instead of being charged with possession of a prohibited firearm and charged on part 2, I'm not sure what would happen in an instance like that, but I think that the application of reverse burden was always intended to be for this particular part. So it's really I don't think it was ever meant to be a general application. It was really to be narrowed specifically for part 2 of the legislation. So it's not necessarily.
And that's where my head. I know, Minister, Chairman, DPM, your position is that, and I'm sensing that you're saying it's not necessarily. I mean, the legislation, that provision may not need to be inserted at all. My leaning, having listened to Mr. Richards and having listened to the Solicitor General's Department or the Attorney General's Department and the SG, is that if it is properly narrowed and if the ease of achieving the information, ascertaining the info, the registration details, is somewhat complex and difficult for us here, then in my view, it would lean closer to satisfying the test, the constitutionality test. The issue, though, there would be the penalties, the question of the sentence, and as SG outlines, where the sentence is significantly custodial, then the courts tend to shun to kind of have a higher test. Well, tend to shun the use of the reverse burden. So I think that perhaps, as the SG requests, that perhaps Mr. Richards could outline the narrow circumstances, clarify that for the SG. We have timeline, we have a time frame. We don't know how quick that can be done, but I think, in my view, there is some scope, there is some hope for the reverse burden in those limited circumstances. That's just my input.
No, I hear you loud, and I said I take legal advice from all my learned friends. And I first of all, I tend to agree that the section B will have to be removed, whatever happens. There's any other matter of exceptional defense. Doesn't seem definitely too broad. There could be room for an A, but as I said, it's a question of another word of legal expression I've learned from you in this committee is proportionality. Because the kind of cases you are referring to are rare, as the old people say, rare as hen's teeth. You're really finding a man, I said, who tell me he's a handy and fisherman with a licensed firearm and him come to Jamaica without it. We may have intelligence that he's really a trader, but we'll have to use additional evidence to say that he's a trader. Whatever intelligence, we'll have to find a way to convert that appropriate intelligence to evidence, because are the more localized one, the entertainer you find with a rented car with a gun in it. And indeed, he may not have an unlicensed firearm. But I don't think he's a person who want to lock up a life just for that. There must be something else to attach that. Plus, if it's a rented vehicle, I'm saying find it in there. I don't think you have, he won't have any burden. He won't have any lives to go to. So I don't know. I'd love to see a case that this applies to, really, illustrationally. I'm not sure. I'm not convinced that it's absolutely critical clause for this bill. And I still cannot visualize, Mr. Richards, and on the other hand, the case where we would have to apply this. Really? I said the only ones I'm concerned about, I think there are other ways of dealing with it. That is the tourist coming in with a gun in his suitcase, inadvertently, and finding it when he's going back out. But which is a different kind of operation. All right. It seems to me, Mr. Richards says he can get all the explanation to the SG by this evening. I'll allow it to go through, and we'll discuss it again tomorrow. But I said, Mr. Richard, I need a little more outline of the kind of case you're referring to that really requires the senior. Okay? Not the time I'm concerned about. As I said, it is if we intend to test the judgment, then put it in rather, I'm a layman there, but I hope I don't use the extreme language here, Senator. You correct me if I'm wrong, but if we were to find another case to go and test the judgment, SG, I'd want a case that is stronger than this. I find this, I'm not sure I'm seeing any. I'm still not seeing any clear-cut case to test the reverse burden proof on severe sentencing using it in this way. But Mr. Richards, send the explanation to SG. You can give me some more, some more outline on the policy issue as to why it is necessary. Because I'm not fully convinced I've got the argument from the SG and that they seem they're quite clear from Ms. Thompson, and I'm not sure we have the incident of cases that require this testing. Senator Motley, for intervention, I said it's not the timing. It's pushing the boundaries of our case so far. We need a good reason to do it. And I am not yet seeing the reasoning for it, quite frankly. But Mr. Richards, put the thoughts together for me. But I said,
before Mr. Richards comes in, I apologize, but I do have to step out to a hearing, so I'm going to ask to be excused.
All right. So
I expect we will speak about this issue tomorrow.
Minister, I was saying that my reference to the timing was to give everybody the opportunity to ventilate their concerns.
Yes.
So that we could see, one, is it of general application? Two, is it really necessary in all the circumstances? Can it be used and be in a manner which makes it constitutional? Those kinds of things was what I was hoping would be converted on.
Thank you very much. Yeah, that is really, our concerns are really on the same, of the same kind. We're on the same level with that. Like, I need to get a better understanding of why we need it and what case we can focus on. And certainly, is it justified to bring it in this particular legislation? So I think we're on the same line, Senator. On this occasion, of the same color.
Pardon me, Chair.
Okay.
So there is an outstanding issue. I'm not sure if the committee had addressed it. Submission was received from Mr. Dalling in June regarding clause 47.3. I'm not sure if the committee had addressed it since we started meeting again in June.
What was Mr. Dalling saying here?
The
three has.
Based on the conclusion of his submission, it's saying that it is a position of the FLA that carrying a firearm or ammunition in the public space without the appropriate authorization should remain an offense at first instance, and the person shall not be given the opportunity to produce the authorization within 24 hours upon providing the person's name, address, and identity to a constable. I'm not sure if we had addressed it in the last meeting, sir.
We did discuss that, and the agreement was that the constable could detain the firearm, but would give the person 24 hours unless they have other evidence to suggest that the person is crooked. I think that was the sum of what we had agreed to, because the point is, if he Senator Sinclair want to come and say, let's send it on, because if you know the supermarket or down the road leave his firearm at home, you don't lock them up same time. On the other hand, if you have other evidence that you need to do, Senator Sinclair, go ahead. I think you had raised this issue quite clearly.
No, I in fact, I was opposed to the time. I believe that persons who who are carrying their firearms should have their permits. So I believe it should be an offense. And I think the majority of members were of the view that there should be afforded an opportunity to get to produce it in 24 hours. I think it also came back up in another subsequent clause where it said that it was a defense.
It makes a fixed fine. It is one of the matters we could make a fixed, what do you call it, fixed fine.
But the question, the fact that a person is, because I think what your concern is, Chairman, Minister, is that you don't want to criminalize persons who may have their permit but may have left it at home.
Right.
When you say criminalize, you mean that they are fingerprinted and have a record, right?
Yeah,
is that what you mean?
Yeah.
Pardon me?
Yeah.
But if it is excluded from the fingerprint act, because there are offenses that go before a court, still, person can be charged, but there is no fingerprint that is taken. So they do not end up with and they may pay a fine, right? So the Offensive Weapons Act, persons are charged for having an offensive weapon in a public space, but those persons who go to court, they are not fingerprinted. It doesn't give you a criminal record. So if that is a requirement that or can be put in the act, similar to the Offensive Weapons Act, then you will have the benefit of it. But I believe that a person who has the responsibility, they applied for a firearm, they must accept all the burdens that go along with it, which one is to ensure that when you go into the public space, that you should ensure you have your permit. That is just my view. So my view, I believe, is similar to that expressed by Mr. Dallin.
Yes.
And I am not. I've not been.
Same play.
I've not been. Pardon me?
Was in agreement. I said on this occasion yourself, Mr. Dallin was in agreement.
You know, and that is very, very strange because I tend to have a little different view from Mr. Dallin, but I am strongly in support of the position that a person who takes upon themselves the responsibility of applying for a firearm, getting a firearm, should bear the responsibility and shouldn't give our police all this hassle. This is more work for the police. If a police officer now has to ensure that the person brings in the fire, the thing within 24 hours or go and search for him or as a kidnapper.
I know the amendment put in place here basically reflected the majority view that the person not able to produce the appropriate firearm authorization when so required under Section 1, but is able to satisfy a constable as the person's name, address, identity, and that the person in fact the holder of a firearm authorization. A, the constable shall retain the firearm or ammunition as the case may be and permit the person to produce the firearm authorization within 24 hours thereafter.
Yes, Mr. Chairman. So I believe that I'm in the minority and I will remain in that position.
Specified by the constable at the time when the firearm authorization was required to be produced under subsection 1. And the firearm authorization is produced pursuant to a paragraph that person shall not be liable to be convicted of an offense under subsection 2, and the firearm or ammunition as the case may be shall be returned to the person. It would satisfy if you insert here a fine without, like a traffic ticket without him being charged. Can that be done? When it comes to recover his firearm, or when he's fined $50,000 for leaving his license at home, can that be inserted without having him, as I said, charged?
You see, the problem that I have with it is just that in the event that that person is able to satisfy the officer that of his name and identity and so forth, but he does not have a firearm authorization. And he decides, well, guess what? I got 24 hours and I am not going to go back to any police station. Then the police now is burdened with having to find that person.
Well, you'll have to charge him.
That he's not charged, but obviously he was in possession of an illegal weapon. And I am of the view that I shouldn't be burning the police officer to go and have to look for that person. The police officer could have taken that person in charge him. If they have to give him bail, so be it, as the case may be. Or somebody quickly takes his authorization to the station and the police can exercise his discretion to say, well, all right, you produce it in a very short time and not wait to charge you. But I'm not supporting this opening here at all. And if your concern is about creating a criminal record, then the person who produces it really doesn't have to be fingerprinted. Doesn't have to be fingerprinted.
Yeah. MP Williams.
Yes, Mr. Chair, thank you. I think Senator Sinclair is emphasizing a strict liability approach, for want of a better legal term. So, strictly speaking, you must have your identification, authorization on your person, which would send a message that we are, serious. This whole statutory regime is serious about firearms possession, and and it would send a strong message. And I understand where the FLA is coming from, and Senator Sinclair, in terms of the burden on the police. I think that making it a non-recordable offense would satisfy the position of not wanting to impose or criminalizing authorized firearm holders. So what you're basically criminalizing is the fact that you don't walk with you never had your authorization on you, but you make it an offense, but not a recordable offense. So in the sense that it wouldn't affect and it would send, in my view, send a strong message. So I am somewhat sympathetic to the FLA's position, because a man who has an illegal firearm, no authorization, the constable says, okay, I'll keep your gun, go and get your, prove it within 24 hours. That man doesn't have an authorization and he goes on a flight and he's out of here.
It's not too many like those,
But I'm somewhat sympathetic to the position, really, but I guess it's for the committee.
I mean, this clause has raised a number of what I call interesting anomalies. Is there really, I disagree with Senator Charles Sinclair in the matter in these areas. And is there really Senator Sinclair agrees with Mr. Darling? And Mr. Williams. But, I said the issue was, you can see whether it can be done and amended in there. I don't know, but we had agreed to do it this way. I said it was the majority had agreed to do it this way, and the CPC have so amended the clause to reflect that majority thought with that. I had come on the side against the FLA because I said my thoughts, the FLA, is that once we separate the prohibited firearms from the legal firearms, why we're not making it a light matter to have a licensed firearm. I think we ought to be more accommodating of the people we grant firearm license. And the object when this bill is put through is that they'd have to go through a bit more appropriate training course and a proper manual given to them outlining with what's in this firearm act and also how they should manage their firearm. In other words, FLA has to accept a greater level of responsibility in educating those granted license while being more liberal in granting Jamaicans who need firearms. Because right now as often said, you have not shown the need for a firearm. It's a kind of broad clause that the FLA used very loosely.
What your comments, though, Chairman, is really their last comments is a separate issue altogether from the one that we're dealing with. Just a separate issue.
Yeah.
So I don't think we should mix both of them. This particular clause is one that says this is the scenario to it. A person, we start from zero, where the person does not have a permit, doesn't have a right to have a firearm, and the person chooses to burn himself or herself and applies for a firearm and goes through the process. And they get the privilege of being a firearm holder from the FLA. Having gone through all of that, and they have gotten that benefit, they are to accept all burdens and responsibilities that goes with it. And one, the FLA is asking that persons whom have been given this privilege must, one of the things is that they must have their permit with them in the public space. Once they go out in the public space, you must have your permit. Another thing that we are seeking to burn is that you must ensure that you wear suitable clothing, that you do not expose your firearm in a public place.
But that's the law that you should not be unduly exposing it. But you know,
right. So there are certain burdens that exist, and they are there for whatever the particular reason. And in this particular case that we're dealing with, where are we going to go burden the officer? Officer satisfies himself. It seems to be a privileged position, to be honest with you. Meaning to say, Chairman, you may be able to satisfy the police officer because you are in the position of a minister with a public face, right? Face that is known to many. But you may have another person who is not so privileged as you are. But this seems to be a provision that is even protecting the privileged, and I'm using that term very loosely. Yes, everybody should, once you go in the public space, ensure you walk with your permit or you face the burden. Do not put the burden on the police officer to having to go and search for you.
Not the privilege. You're giving everybody a break, including the possibility of giving a criminal a break, because you're saying he can bring back.
And I am not supporting that. This clause is going to work more for those who find themselves so privileged that they can easily to an officer. An officer can say, yes, I'm satisfied that you are Dr. Chang because I see you on the TV every day, and etc., etc., etc. But John Brown, who is down the road, who doesn't have that, not going to get that.
John Brown can bring his license in 24 hours.
Huh? But he cannot satisfy the officer.
No, man, John Brown must have an address and he must have an ID if he's driving a car.
And that may still not satisfy the officer because your persons don't update their license with their proper address. So you have persons who are driving with driver's license, although the law provides for it, that they do not update the TAJ with their correct address. And NIDS does not carry an address.
I may change my farm from smaller farm.
So, as I said, Chairman, I don't want to have a public debate with you on the issue. I am not supporting that provision, and I will remain in the minority. If the majority of the committee goes with it, then fine, they go with it. But I am not supporting.
But they gone with it. I don't know.
Yes, I think they did. I think they did.
That's why the clause was inserted. So Ms. Anita brought it back, which was correct. Yeah, they brought in the appropriate clause. But let's say the person, when I am now traveling as minister, and a senior minister of government, I have a CPO all the time. I don't carry a firearm with me. You know, I very rarely carry a firearm. And because I'm well known out there, I don't carry it with me all the time. So after a while, I get, no, what I used to do is to carry my license all the time. No. But in a different circumstances, it means my license is separate from a firearm. I'm going to put them together now, but I know out of government, and I want to go out and I still get security, get CPO, but I don't have a CPO. I might pick up my firearm and leave my license somewhere else. I don't need a wallet. I don't think that should be an offense. I just said that allows me as somebody well known that they will say, fine, come back.
Well, Minister, sorry, this is Alana Wanlace from the FLA. Just to say that the FLA takes the position of Senator Sinclair.
No, it's a good position, but as I said, went back to when I took the position, and as I said, very rarely differ from Senator Charles, is that part of this bill's entire construct was to treat the licensed firearm holder a little bit different, significantly different from the man with legal firearm.
But we also have to make sure that we hold a licensed firearm holder to a particular standard. If they're being granted a particular privilege. As Senator Sinclair has said,
it's like,
this is not a right.
Like the bird shooting they were talking about, we're giving them bird shooting permits.
But Minister, respectfully, this is not a right to which any citizen is entitled to. And Minister, looking at the crime rate that is currently in Jamaica. Pardon?
I'm going to take that well, I think it's all going to legal, go on the street.
No,
so
but even so, we need to legislate to not only be accommodating to firearm license holder, but to ensure that the firearm that they have a license to they continue to hold it they are held to a particular standard and continue to use it and utilize it in the way that they're granted.
We'll hope by the time this bill comes on stream, effectively next year, you'll have NIDS and you have smart check. So once a man comes to the policeman and they have a license him, or the police put him name in him.
But Minister, that can cause a lot of problems because, for instance, suppose they're in a certain area, a remote area where they don't have particular access to certain.
Police stations have access. They can use microwave.
No, but if they see a person in not close to a police station, if they see a person that is in a remote rural area and they won't be able to access certain.
No, the police car has microwave across the island now. They finished put up the last two antennas, including South, St. Elizabeth, and Portland. So they can always go and carry it and know that this man have a firearm license.
And in the circumstances where
unless the man bogus the name and thing. No, him have no circumstance fail.
Because
I have to assume it work. That's what I said.
I think that's a strong assumption, Minister. A very strong assumption. I just think, Minister,
I said the majority agreed, Senator, and that wait till we come to debate, we recognize, but I don't think.
Yeah, I think
I would reverse at this stage.
Yeah.
The issue of the reverse burden and the early listing, I really have an interest in that because I don't know how we'll allow them to sort out that overnight, and we convene by Zoom tomorrow at 2. Right, so we can do the reports. Sarah said it out that I said I very rarely disagree with that, but I think the majority will agree that I think there's still, it works both ways. There are a lot of burden on this to be done by the FLA to sensitize the people on the responsibility, and a lot to be done by, there are still some heavy fines in there for the people with licensed firearm and fees to be paid, including to get the firearm license when not, to appeal it and to know what the fines are if he gets out of the line. There's several fines in here of significance, although there are no confined to parish court, there's good fines to hold them accountable. You could hold that. And Zoom tomorrow, 2 o'clock sharp. Thank you. Let me thank those who are on so we can try. We have come a long way. This bill, I'm keeping my fingers crossed. Mr. Richards. Mr. Williams, still have your hand up?
No, Mr. Chair. No, Mr. Chair. Sorry, I'll take that now.
Senator, I have to give you a call and we'll be able to look at our some activities that we have had funded, and I'll deal with the football competition as well. Senator Charles Sinclair. Senator Scott Motley, you're going to say, come in.
Yes, Chair. I was just reminding you that you have more than one senator on the chat, and I'm sure that invitation was not intended for me.
Scott Motley is. I have a different experience for Senator Scott Motley, who said that on board. You know that center that if it's even the tone of my voice would change when I'm addressing Senator Scott Motley.
Thank you, Chair. It was a pleasure to be able to join. I have to leave now. I have to.
No, we are closing off.
I will be back in Jamaica later today.
All right. Good. Thank you much.
Bye.
So tomorrow we hope we can tidy up at the 2:00 meeting tomorrow.
Yes.
And the outstanding issues. But thanks all for joining and thanks for getting us here. Not saying thank you to closing off yet. But Neela, you have been given some time to wrap up the report so tomorrow we can do what we have to do. I know it's hard pressure on you, but thank you very much.
Okay, sir.
All right. We adjourn tomorrow at 2:00. Same venue, same media. Thanks again to everyone. Ms. Thompson.
Sorry, Chair. Oh Lord, sorry.
The data to you tonight, but as
Chair.
Yeah. Go ahead, SG.
Yes, sorry to just jump in here, but I'm sorry to put you on the spot, Mrs. McCarthy, but would the report be sent early so that we could start looking at it? Because you know the support that the chambers would give as it relates to the report.
Yes.
I'll talk to you, SG. Thank you.
Thank
Okay.
you for the reminder, SG. And SG, that will give me a lot of trouble, but your father's
No
motive to
trouble.
deal with trouble. Thank you
No
much
trouble.
for the
No
support you have given me.
DTM. It's never any trouble.
And all the instruction, beside the instruction they give me, thank for your teaching sessions with me in law. I was a young man, go back.
Yeah, let anybody know.
All right. Thank you, SG.
Thanks. Bye.
Right. Okay, to all team members, thanks again. And tomorrow, legal reform, and they're on this grant, and they're there.
Yes,
Can you hear your voice
Minister.
there?
Yes,
Thank you.
Chairman. Legal
Nadine and
reform
Judith.
is here. Yes, sir.
All right, so tomorrow at 2:00, we hope we can complete the marathon. I see they're running much faster marathon these days. The ladies in the World Champs have done some very rapid marathons and long meter. But thanks again to everyone. Have a good evening tomorrow at 2:00. Thank you.
It's Jamaica's Diamond Jubilee, celebrating 60 years of independence. Jamaica Festival Queen, Jamaica Gospel Star, Jamaica Festival Song, Independence Float Parade, Independence Street Dances, Grand Gala, and a whole lot more. Check the press for details and join us for the excitement, or watch it live on TBJ and PBCJ.
We are now open and ready to take our women in who are being abused. The facility will accept clients even while we continue to receive donations and build out our programs to help women to rebuild their lives and get back on their feet. I use this opportunity, Madam Speaker, to read out the 24-hour hotline numbers for women who need the shelter. 876-553-0372 or 876-929-2997. The other two properties are now in early reconstruction and or refurbishing stages and will be transformed quickly into safe spaces for women.
For little people, it's a really big world. A big world to discover and explore. And because discoveries aren't always easy to understand, little people need help to make sense of the big world. So help them make sense of the world. When you CPG, do PG. The Broadcasting Commission, your partner for a new day.
Coronavirus is in Jamaica, and I know you feel scared and worried. But you can't let COVID-19 divide us. Coronavirus infects all kinds of people. It doesn't discriminate. So why should you? When someone coughs or sneezes or shows signs of the virus, tell them to call 888-1-LOVE immediately. And remember, stay 6 feet away, but don't attack or disrespect them, because we're all in this thing together. Come on, Jamaica, cut the hate and don't discriminate. Let us stand together and fight COVID-19 as one family, one nation.
Cockpit Country, Jamaica's heartland.
As you can see, it's a farming community, very deep rural. And if the company should come now and mine these lands, then the livelihood of the people would be at stake.
Home to many Jamaicans who love where they live and want to make sure it is protected.
One of my major concerns is the water stable. From Old Trios right back to Montego Bay, all of these water come from the Cockpit Company. When the bauxite company mine these places and chop the water stable, what are we going to do?
We're having the problem with the water in the city, in the school. The top of the school, which we use as the main source of catching the water, the catchment for the town. And then when they dust accommodate there, then they wash into the tap. And the children have to use the same water to drink.
The government said they will not allow mining in the Cockpit Country protected area. But that doesn't protect the areas that lie just beside it.
So just because you're outside of the protected area boundary doesn't mean that you're not still a part of Cockpit Country. It's still connected above ground and below ground.
That means anything we do very close to the boundary, like mining, can still hurt what lies in the protected area. Find out how you can take action to protect Cockpit Country by logging on to www.savecockpitcountry.org.
How do bills become law in Jamaica? Laws are made to create order, to ensure our safety, and to protect our rights against abuses by other citizens or